All right, so if you've done any volume of real estate wholesale and novation, you've probably have had some sellers wanting to back out. This is very common. They get cold feet, they get other offers while they're in escrow with you, or maybe even a buyer goes around your back and actually tries to steal the deal from you. Now, in this video, I'm going to cover a scenario where we actually had the seller send us $25,000 just to get released of the contract. I'm going to break down exactly what are the documents that were needed for this and how you can use it in your business. So stay till the end and make sure to check out the comments below and resources below so that you can actually get your hands on these same tools and resources. Now, I'm going to lead with the fact and disclaimer that this is not legal advice. This is not financial advice. This is for information purposes only, and you should seek your own legal counsel. But I'm simply just sharing a real life scenario and case study in which a seller actually did this because they felt that they could get a lot more on the open market, but they were already in escrow. Okay. So the first thing that I'll say is that you need a binding earnest money contract, meaning that all of the people that are vested in title have signed that contract. You have put earnest money at the title company or the chosen escrow officer office or attorney office. And that contract has to, per the state regulations, go ahead and allow you to place a memorandum of contract, meaning it's not quite a lien, but essentially a title company should not insure around it because it allows you to actually cloud title. So in this case, this property was a tenant occupied property and we got it under contract after a bunch of negotiation, right? Right now in this market, it's a dog eats dog type of situation because we are in a down market. There's a lot more listings and competition out there. So this wasn't a one cold close per se. And in your purchase and sales agreement, you have to have the verbiage that actually allows you to be able to put that memorandum of contract and just be able to disclose that you're an investor and that you have the right to make the seller perform, known as specific performance. Okay. Now, what happened was this seller, probably like a week after, says, no, I don't want to close. And, at this point, we've started our due diligence to close. We're performing per our obligations of the contract. And we go ahead and listen, I mean, we have a contract. We do want to close unless you want us to get, an attorney to actually sue you for specific performance. And this is not only for wholesaling real estate. I mean, this is actually applicable on retail side as well. If a seller is trying to back out of a contract they already signed, those contracts are contracts. They're enforceable for a reason. And so in that case, we try to coach him, let him know, like, listen, we need access per the contract. You're not allowing us to get access. You're not allowing us to do what we need to do to actually get close per the terms. And so we essentially shared, what a memorandum of contract is and what the next step would be, which would be a lis pendens. It may be named differently in your state, but essentially is when you actually get an attorney on retainer to start the process to sue for specific performance. And I don't recommend going down this path unless you're absolutely sure that this is a deal that would make sense for you and that you actually want to pursue. Ultimately, the sellers and yourself in your office, you had a conversation because the seller wanted to sell and you wanted to buy. Now, if you feel that perhaps you either overpaid or the property condition is way worse than they mentioned and that your numbers are going to be way off, then you definitely don't want to kind of go through all this madness without knowing for sure that it would make sense. Now, after we filed the memorandum and kind of educated the seller around the process here and what the options were essentially you either sell to us as agreed, or you essentially pay us what our projected profit's going to be. And so at that point, we have proof like, listen, this is what we're budgeting. This is what we're having under contract. This is what we're projecting. He made the choice. He actually made the choice to go ahead and send us, that agreed amount, which in this case was $25,000. All right, and this is the first time that happens to us. It's not common. Typically, sellers will ghost, and whenever they want to resell, they reach out for an invoice. What I've heard from practice and what I've been consulted on by our legal counsel has been to make sure that you have all of your disclosures, you have your documents, well prepared, and your earnest money at the title company, and that you have written statements saying like, listen, this is going to be the invoice if you're essentially going to be not performing with us, and you're going to seek and you're going to need a release in the future. The other piece that could be tricky is if you're dealing with like heirs and you're not sure if you have the signatures of all the parties. I actually had a situation in which we got a signature of one of the heirs, not all of them. And so at that point, it's a little bit iffy and grayish because you could be accused of like slandering title, which you don't want happening. The other piece that you have to be aware of is like if there's somebody else that filed a memorandum before you, that person could essentially sue you as coming in a second for interference. And so nobody wants that. That's gonna be like a bunch of legal fees, and it's just gonna eat away at your profit. And so with that said, just make sure that you have your documentation set up for success. So check the links here below. We got some resources that you can use to actually apply this in your business. And let me know in the comments what sort of questions you have. We'll make sure to make videos on those in the future.